Hi everyone, I'm here with my friend attorney Christine Bernadini. Bernadini Law is in North Andover, and you practice real estate law?
That's correct.
And Christine recently spoke at my sales meeting, and we talked a lot about landlord-tenant issues and concerns, and it was pretty interesting, so I thought we should cover some of these things. So for a landlord, there's a lot of rules and guidelines you need to follow. And I think it's very important you have to follow them exactly to a T. Is that kind of what you're saying?
That is correct. Massachusetts is a very, very tenant-friendly state, mostly because of the fact that if you own a property as an investment property, you're considered to have a little bit more superior knowledge than the regular homeowner. So the laws are very, very particular in what landlords have to do in order to properly rent their properties without, having any sort of potential litigation in the future.
Yeah. So always some sticking points are deposits. So legally I think you can take a first, a last, you can take a security which cannot be greater than one month's rent.
That's correct.
And you could charge a fee for the lock. And I see a lot with my friends and clients that that security deposit. That's so what is the guideline? What do you need to do with that security deposit?
The security deposit is probably the most important thing that a landlord needs to keep in mind. It's probably one of the #1 things that will open them up to any potential litigation if it's not properly held. That security deposit needs to be placed into a separate bank account, and it needs to be an interest-bearing bank account with both the landlord's name on the account and the tenant's name on the account. So if you don't place it, say you place it in your own personal funds, that's not properly holding the deposit, even if you wrote any extra interest on top of it at the end of the year. So it does need to be held in that separate interest-bearing account, and you need to furnish a receipt for that deposit to the tenant after that account is established.
Yeah, that was a recent case that we saw. We ended up in housing court, and it was just a minor detail of how they provided that notice of the account. They wouldn't even hear the case for the landlord, and it was just a bad outcome. So you have to follow these guidelines very closely.
One more thing I just want to add to that is if it's not properly held and the tenant files a claim for that at any point in time, it does subject the landlord to potential treble damages. So that's 3 times the amount of the security deposit, plus if the tenant hires an attorney, it gives them those attorney fees as well.
And I think that's back to sort of the housing court. They are really going to look favorably to the tenant, and
that's correct.
You don't want to find yourself in housing court at all. A statement of condition, that's an important step. What do they need to do about that?
The statement of condition needs to be done within 10 days of executing the lease by both parties. So once we have the lease fully executed, signed by both the landlord and the tenant, it's essentially almost like a walkthrough when you're purchasing a property. So you have written down on a piece of paper the condition of the property. You essentially walk through it with the tenant, try to look for any defects in the property. If there were any holes in the wall or any scratches on the floor, you're going to make note of that. And once the property is fully walked through, so every livable room is walked through, you're going to have the tenant initial and sign on that document, certifying that this is the property that they took it in that same condition at that point in time. What will happen for the landlord is that this is the document they will need once the tenancy ends. They will need to use in order to determine whether or not there was any damage done to the property where they could potentially hold a portion of that security deposit to repair.
Yeah, so another very, very important step. You have to do it the right way. There's a state sanitary code. I mean, that's something that I think a landlord really needs to read and understand and know what code violations are. I think
yeah, even more particular is the local city or town board of health. If a tenant really wants to cause some problems, they can call the board of health, and the board of health comes out and finds any conditions that they don't feel are considered to be habitable. That will subject the landlord to fines, and the fines could continue until those items are repaired. And it could be potentially costly, and it could be something that needs immediately repaired, and so that they have to try to find somebody and expend more money at a short period of time trying to find somebody who's able to actually get those repairs done so that they avoid those extra violations.
Yeah. There's some resources out there. for the Merrimack Valley, you can call the housing court. They have housing specialists there, and they will answer all of your questions. That number is 978-689-7833. I think this is a serious enough issue that if you are a landlord and you're bringing in new tenants, I would use an attorney. If I'm working with property owners to find tenants, I'm still going to recommend all the paperwork is handled by a real estate attorney to ensure that it's done properly. So we'll give you some contact info for Christine, and you can always email me any of your questions. Thank you for chatting with us.
Thank you.